Imagine you are an inventor in London, right in the thick of the Industrial Revolution. It's 1880.
Okay, setting the scene. I like it.
Yeah, so you've just spent 5 years of your life and basically your entire life savings perfecting this revolutionary new high-pressure steam valve.
Yeah.
You patent it. The British government puts this metaphorical fence around your idea.
Right, so you have that legal protection.
Exactly. Anyone in England who wants to build your valve has to pay you. You feel
Mm-hmm.
completely secure, but the very second your blueprints cross the English Channel and land on French soil,
It's an absolute free-for-all.
yeah, anyone in Paris can take your design, manufacture it in bulk, sell it across Europe, and, you wouldn't see a single dime. Your British fence simply does not exist in France.
And that invisible border is really the crux of the entire global intellectual property system. I mean, you could put a physical iron fence around a farm or a factory, right?
Yeah.
If someone climbs over it, it's trespassing.
Right, it's obvious.
But putting a fence around an intangible idea, like a chemical formula, a brand name, or a piece of software, and making sure that fence holds up no matter where you travel on the planet, that is a remarkably complex challenge.
And that challenge is exactly what we are exploring today. We are stepping into the shoes of a law professor to guide you through Unit 2 of the Osmania University LLB syllabus.
Which is a fantastic unit.
It really is. We've got a massive stack of specialized legal study materials, university notes, and case laws detailing the evolution of international intellectual property rights, or IPRs.
It's a fascinating journey. We're going to trace how the world went from that chaos of the 1880s to the deeply interconnected, highly regulated global trade network we live in today.
Yeah.
And to understand why this massive web of international treaties exists, we really have to look closely at that steam valve scenario you brought up. The core problem driving all of this is a legal concept called territoriality.
Okay, let's unpack this because, territoriality sounds like a concept for real estate, not ideas.
Well, in a way, it is. Territoriality means that an intellectual property right historically only existed within the geographic boundaries of the sovereign nation that granted it. So your rights stopped at the border.
Which is a huge problem.
Huge. As international trade absolutely exploded during the 19th century, this became a massive economic crisis. Inventors and creators were actually refusing to showcase their products overseas because they were getting ripped off the moment their ideas left their home countries.
So the global economy was basically stalling because there was no trust.
Exactly. The world desperately needed a unified legal framework.
Which sets up this escalating series of historical conflicts. First, the world had to figure out the basic rulebook. And looking at the materials, they split that rulebook into two distinct tracks, the industrial and the creative.
Right.
Let's start with the industrial side. It's 1883, and the world gathers for the Paris Convention.
The Paris Convention for the Protection of Industrial Property. Now, when we say industrial property in this context, the source materials are referring primarily to patents for inventions, trademarks for brands, and industrial designs.
Basically the nuts and bolts of commerce.
Exactly. This treaty is the absolute cornerstone of global IP law. It introduced a few revolutionary mechanisms to solve that territoriality crisis, but the most critical one is found in Article 4.
The right of priority.
Yes, the right of priority.
Let's walk through how this actually works for you, the listener, if you were an inventor back then. Because before the Paris Convention, if you filed a patent in your home country, this terrifying clock started ticking.
Oh, it was a nightmare.
You essentially had to charter boats and trains, frantically racing around the globe, trying to file your patent in every other country simultaneously.
Because if a rival saw your invention in London and beat you to the patent office in Berlin,
They owned your invention in Germany.
yeah, it was a logistical nightmare that heavily favored whoever had the fastest ships and the most money. The right of priority completely neutralized that race.
Thank goodness.
Under the Paris Convention, if you file a patent application in one member country, you are granted a 12-month grace period. You now have an entire year to file in any other member country.
Wait, so you get a whole year?
A whole year.
Huh.
And the brilliance of this mechanism is that if you do file within that year, those subsequent international filings are legally treated as if they were made on the exact same date as your very first filing.
Wow. You essentially get to hold your place in line across the entire globe for a whole year. You don't have to race. You can take a breath, find foreign investors, translate your documents.
It is a massive shield for inventors.
But there's another major pillar in the Paris Convention, right? Article 2, national treatment.
Yes. National treatment is arguably the principle that changed international law the most profoundly. It dictates that every single member country must grant foreign applicants the exact same level of protection for their industrial property that they give to their own domestic citizens.
So no favoritism.
None. It completely outlaws discrimination based on nationality.
I always think of it like being a guest at a friend's house. Under national treatment, you get to play with all their toys and eat the food in the fridge exactly the same way they do, regardless of the fact that you don't live there.
That's a great way to put it.
So if you, a listener sitting in Japan, invent a new solar panel and file a patent in India, the Indian government is legally obligated to treat you with the exact same legal respect and protection as an Indian inventor.
That levels the playing field globally. So that was the industrial side in 1883. Just 3 years later, in 1886, the international community realized they needed to protect the other half of human ingenuity.
The creative side.
Right. Which brings us to the Berne Convention.
The Berne Convention for the Protection of Literary and Artistic Works. So we're moving away from steam valves and solar panels and diving into novels, paintings, musical compositions, and eventually movies.
And because the nature of a painting is fundamentally different from the nature of a mechanical valve, the Berne Convention introduced a completely different mechanism, automatic protection.
Which is Article 5.1.
Exactly. With patents or trademarks under the Paris Convention, you have to actively apply, prove your invention is new, pay registration fees.
It's a whole process.
It is.
Yeah.
But Berne established that copyright is granted the absolute moment the creative work is fixed in a tangible medium.
Meaning, if you sit down at a coffee shop right now and sketch a character on a napkin, the second the ink dries on that paper, you automatically own the copyright to that drawing across all Berne member countries.
Yes, automatically. You don't have to mail it to a government office. You don't have to pay a fee. You don't even have to put that little C in a circle at the bottom.
That is wild.
That is the power of automatic protection. It removed all the bureaucratic hurdles that might prevent an independent artist from securing their rights. Alongside this, the Berne Convention established minimum standards for the duration of that protection.
Which is pretty generous, right?
Very. The sources note that generally this protection lasts for the entire life of the author, plus an additional 50 or 70 years after their death, ensuring their heirs benefit from the work.
But the part of Berne that feels the most human to me is Article 6B's, moral rights. Because up until now, we've been talking about intellectual property purely as an economic engine.
Right, as a commodity.
Yeah. But moral rights acknowledge that an artistic work isn't just a product. It's an extension of the creator's soul.
That is a crucial distinction.
Yeah.
Moral rights separate the economic value from the personal value. It grants the author two distinct powers. First, the right of attribution, the legal right to always be named as the creator of the work. Second, the right of integrity. This means the author can legally object to any distortion, mutilation, or modification of their work that would be prejudicial to their honor or reputation.
So if you write a deeply serious, tragic novel, and a publisher buys the rights and decides to slap a cartoonish comedic cover on it that makes you look foolish, you can step in.
Absolutely.
Even if you've sold the economic rights to print the book, you still retain those moral rights to protect your reputation.
What's fascinating here is how these two 19th century treaties, Paris for the industrial, Berne for the creative, laid down the permanent bedrock. Concepts like the right of priority, national treatment, and automatic protection are still the foundation of the global IP system today.
Okay, so the foundation is built. We have the rule book. If I invent something, I have a year to file globally. If I write something, it's automatically mine. The rules are sound. But let's look at the escalation of this conflict. Because having the same rules everywhere is great in theory. But in practice, if you are a growing business in the early 20th century and you want to protect your new brand logo in 50 different countries.
Oh, the paperwork.
Exactly. You still have to hire 50 different local lawyers. You have to translate your application into 50 different languages. You have to pay fees in 50 different currencies and navigate the specific bureaucratic quirks of 50 different national patent offices.
The paperwork alone was enough to collapse the system. It was an insurmountable barrier for anyone but the most massive, wealthy corporations. The international community had to figure out how to streamline the bureaucracy.
And looking at the syllabus, they tackled trademarks first in 1891 with the Madrid Agreement.
The Madrid Agreement fundamentally changed the mechanics of global brand protection by centralizing the registration process. Instead of filing those 50 individual applications, a trademark owner can now file one single international application in one language and pay one set of fees.
It sounds like the ultimate online checkout cart for international law. You basically look at a list of member countries, check the boxes next to the ones where you want to sell your product, and a central system handles distributing your application to all of them.
That's pretty much it.
But wait, let's look closer at the sources here. Just because you check the box for France or Japan, that doesn't mean your trademark is automatically approved there, right?
That is a vital distinction. The Madrid system streamlines the application pipeline, but it absolutely respects national sovereignty. It doesn't bypass local laws.
So they still get a say.
Exactly. Once that centralized application lands on the desk of a national trademark office, that specific country still examines it based on their own unique legal standards. They have the right to refuse protection within their borders.
And the case law in these university notes provides some fantastic examples of this friction, like Nestlé. They tried to use the Madrid system to register a trademark for the actual physical 3D shape of the Kit Kat chocolate bar.
Right, not the name, just the shape.
Yeah, not the name Kit Kat, not the red wrapper, just the shape of that four-finger chocolate wafer. They wanted that shape protected globally.
But when that application hit the European Court of Justice, they pushed back hard.
Right. The court said the shape alone lacked inherent distinctiveness, which basically means if you strip away the red wrapper and the logo and just hand someone a piece of chocolate shaped like four attached fingers, their brain doesn't immediately and automatically scream, "This is definitively a Nestlé product."
Because other companies make similarly shaped wafers.
Exactly.
Yeah.
So despite using the centralized Madrid system, the local court denied the trademark for the shape.
Another excellent example from the notes is Apple filing an opposition against the watchmaker Swatch. Swatch utilized the international system to try and register the slogan, "Tick Different."
Oh, wow.
Yeah, and Apple fought it tooth and nail because it was obviously playing off their globally recognized Think Different campaign.
So these central systems don't prevent legal battles, they just consolidate where the paperwork starts. And speaking of high stakes, we have to talk about the central attack mechanism in the Madrid Agreement, because this is incredibly dramatic for an administrative treaty.
It introduces a significant element of risk. When you file that single international application under Madrid, your entire global portfolio is tethered to your original home country trademark for the first 5 years. They are inextricably linked.
So if you register a logo in the U.S. and then use Madrid to expand it to 40 other countries, your U.S. registration is the foundation. What happens if a rival in the U.S. sues you during those first 5 years, proves you actually stole the logo from them, and the U.S. court cancels your home trademark?
Then the central attack is successful, and your entire international portfolio falls like a house of cards.
Yeah, man.
Because the home registration was destroyed, the international registrations in all 40 of those other countries are instantly wiped out as well. You lose everything everywhere.
It is a precarious 5 years. So Madrid streamlined trademarks in 1891. But it took several more decades for the world to realize they needed the exact same centralized pipeline for patents. That brings us to 1970 and the PCT.
The Patent Cooperation Treaty. The PCT essentially did for patents what Madrid did for trademarks. It created a unified, centralized procedure for filing international patent applications. But for inventors, the PCT offers a very specific strategic advantage. It buys you time.
How so?
Under the traditional Paris Convention, remember, you only had 12 months to decide which foreign countries you wanted to file in and pay all those expensive translation and filing fees.
Right.
The PCT process extends that timeline significantly, often up to 30 months.
That's huge.
It gives an inventor an extra year and a half to test the market, secure funding, and evaluate the true commercial viability of their invention before they have to spend a fortune entering the individual national phases.
So if I'm checking all these boxes for trademarks under Madrid and filing these centralized patents under the PCT, there has to be a massive central clearinghouse processing all of this. It can't just go into the ether.
You're pointing directly to the creation of WIPO, the World Intellectual Property Organization.
Okay, WIPO.
Established in 1967 and headquartered in Geneva, Switzerland, it became a specialized agency of the United Nations in 1974. WIPO is the global administrative hub. They're the ones actually administering the Paris Convention, the Berne Convention, the Madrid system, and the PCT.
I sometimes hear WIPO described as just a massive server routing applications, but looking at these texts, that's not quite right, is it?
No. Treating WIPO as just a passive server drastically understates its role. If anything, WIPO is the United Nations of ideas. It is a highly active diplomatic forum. It's where delegates from all over the world gather to debate, negotiate, and continually update the rules of global intellectual property as technology evolves. They aren't just processing forms, they are shaping the future of innovation policy.
Which brings us to the next massive escalation in our timeline. By the late 20th century, we have the foundational rules, and we have this centralized bureaucracy managed by WIPO. But the nature of the global economy was shifting violently.
Very true.
Intellectual property was no longer just about protecting a lone inventor tinkering in a garage or a novelist writing a book. IP had become the absolute backbone of global economics. We are talking about billion-dollar software industries, multinational pharmaceutical companies, and massive entertainment conglomerates.
The stakes had never been higher. And that economic reality forced the most significant and controversial development in modern IP law, the TRIPS Agreement in 1994. TRIPS stands for Trade-Related Aspects of Intellectual Property Rights.
And the defining feature of TRIPS isn't necessarily what it says, but where it lives. It wasn't just another treaty debated within the halls of WIPO. TRIPS was baked directly into the creation of the World Trade Organization, the WTO.
If we connect this to the bigger picture, linking IP law directly to international trade was a monumental shift in power. Before TRIPS, if a country violated an IP treaty, the repercussions were mostly diplomatic.
A slap on the wrist.
Exactly. But under the WTO, TRIPS gave intellectual property real terrifying teeth. If a country violates the TRIPS agreement today, they can be hit with severe, crippling international trade sanctions.
It essentially weaponized intellectual property, and TRIPS also introduced a new principle to run alongside national treatment. It's called the Most Favored Nation Principle, or MFN. How does MFN alter the landscape?
MFN acts as a global equalizer. It states that if a WTO member country grants any special advantage, favor, or privilege regarding intellectual property to one specific country, they must immediately and unconditionally grant that exact same advantage to all other WTO member countries. You cannot play favorites in global trade.
Okay, but this is where we have to dive into the most intense debate in these legal sources. Because looking at the syllabus, TRIPS caused absolute panic in developing nations. Did TRIPS just hand global monopolies to massive corporations like big pharmaceutical companies at the expense of developing nations?
This is an incredibly complex issue, and the source texts dedicate a lot of space to unpacking it impartially. To understand the panic, we have to look at how patents worked before TRIPS. Many developing countries, such as India, previously only allowed process patents for medicines and food, not product patents.
Let's break down product versus process, because that sounds like dry legal jargon, but the real-world impact is massive.
Let's use an analogy. Imagine a pharmaceutical company invents a totally new, incredibly delicious chocolate cake. A process patent means they have patented their specific recipe, the exact steps they took to bake that cake.
So under a process patent, if I'm a rival baker in India, I can't steal your recipe. But I can go into my kitchen, experiment with different ingredients and different baking temperatures, and figure out a completely different recipe to bake the exact same delicious chocolate cake.
Right.
And then I can sell it, usually for much cheaper.
Precisely. That was the reality. Developing nations were reverse engineering life-saving drugs using alternative manufacturing processes, which kept medicine highly affordable for their populations.
But TRIPS changed that.
A product patent changes everything. A product patent protects the cake itself, regardless of how it is baked. TRIPS mandated a massive shift. It required all member countries to provide both product and process patents in all fields of technology, including pharmaceuticals.
Meaning reverse engineering a different recipe was now illegal. The original inventor owned the drug completely, which sounds like it would immediately collapse the healthcare systems of developing nations by skyrocketing the price of generic medicines.
Well, the negotiators of TRIPS recognized that immediate disaster, which is why the treaty includes vital balancing mechanisms. First, they instituted transitional arrangements. Developing countries weren't forced to change their laws overnight. They were given a 10-year transition period from 1995 to 2005 to fully implement product patents for pharmaceuticals.
But wait, science doesn't stop for 10 years. What happened to all the new life-saving drugs that were invented by Western companies during that 10-year waiting period? Did they just lose their rights in India because India hadn't updated its laws yet?
No, and this is where a fascinating mechanism called the mailbox provision comes into play. TRIPS required developing nations to set up a system, a literal or figurative mailbox, to receive and store these new product patent applications.
So the pharmaceutical company files the patent and India just puts it in a drawer.
Exactly. The patent isn't examined or granted yet, but putting it in the mailbox secures the company's filing date. It holds their place in line while the country spends the next decade updating its legal code.
That's clever.
And to appease the pharmaceutical companies during that, TRIPS provided for exclusive marketing rights, or EAs. If a drug was sitting in the mailbox and it had been approved for sale by the health authorities, the company was granted a temporary 5-year monopoly right to exclusively market and sell that drug, even without a finalized patent.
So the corporations still got their monopoly, just through a different legal mechanism. But let's look at the ultimate safety valve. What happens in a worst-case scenario? Let's say a developing nation is facing a massive, devastating public health crisis, like the HIV/AIDS epidemic, and a foreign corporation owns the product patent for the cure, and they absolutely refuse to lower the price to an affordable level. Are the citizens just left to suffer?
This brings us to Article 31 of TRIPS, which outlines the rules for compulsory licensing. This is the ultimate emergency brake in international IP law. In times of national emergency or extreme urgency, a sovereign government has the legal authority to bypass the patent holder's consent entirely.
Right.
Yes, they can grant a compulsory license to a domestic company to manufacture the patented drug without permission.
So the government just steps in and says, this is a crisis. We are making the generic version whether you like it or not. Do they just steal it?
It's not theft. It's a regulated override. The original patent owner must still be paid adequate remuneration, a reasonable royalty for the use of their invention, but they lose their exclusive monopoly right to control the supply and the price. And to ensure this safety valve wasn't eroded, the WTO later issued the Doha Declaration on TRIPS and Public Health.
And looking at the notes, the Doha Declaration is a powerful document. It explicitly affirms that the TRIPS agreement can and should be interpreted and implemented in a manner supportive of WTO members' right to protect public health and, in particular, to promote access to medicines for all.
It is a profound, highly negotiated tension. On one side, you have the absolute necessity to incentivize massive financial investments in medical research. On the other, the fundamental human right to access the results of that research. TRIPS is the battleground where that tension is managed.
Okay, so we've solved the basic rules, we've streamlined the bureaucracy, we've integrated IP into global trade and managed the pharmaceutical fallout, but here's where it gets really interesting.
Oh, I know where you're going with this.
Because just as the ink is drying on TRIPS in the mid-90s, the world gets hit by an asteroid that none of these treaties were built to handle, the mainstream explosion of the internet.
Yes. The digital revolution fundamentally broke the physical metaphors that IP law relied on. Remember the 1886 Berne Convention? It was written for physical books, oil paintings, and sheet music.
Yeah, tangible things.
Suddenly, we are in an era of digital files. You can make infinite, absolutely perfect copies of a digital work and transmit them across the entire globe in seconds at zero cost.
How does an 1886 treaty handle Napster or software piracy? It can't, so the international community had to react quickly.
They reacted in 1996 with the WIPO Copyright Treaty, or the WCT. The WCT's primary mission was to drag the Berne Convention into the digital environment. Furthermore, it required legal protection for technological measures, like encryption or digital rights management, that creators use to lock down their digital works.
But the most fascinating legal leap in the WCT, the one that the Osmania syllabus really highlights, is how it categorized computer software.
This is a brilliant piece of legal adaptation. The WCT explicitly classified computer programs, regardless of the mode or form of their expression, as protected literary works under the meaning of the original Berne Convention.
Which, when you really stop and think about it, makes a beautiful kind of sense. Code is written. It is a language with syntax and grammar. A programmer sits in a chair and authors lines of C++ or Python to make a computer do something, just like a novelist authors lines of dialogue to make a character do something.
Exactly.
The WCT basically said that a complex piece of software gets the exact same automatic copyright protection as a novel by Charles Dickens.
By defining code as literature, they successfully anchored the most advanced, disruptive technology of the late 20th century to a stable, globally accepted legal framework that had been refined since the 19th century.
We have covered an incredible, sweeping amount of legal history today. We trace the timeline from that chaotic 1880s steam valve leading to the 1883 Paris Convention that built the first international fences with the right of priority and national treatment.
We examined the 1886 Berne Convention, which protected the human soul of creative works through automatic protection and moral rights.
We saw how the crushing weight of bureaucracy was solved by the centralized pipelines of the Madrid Agreement and the PCT, all actively debated and managed by WIPO.
Right.
And finally, we analyzed the modern heavyweights. True press weaponizing IP through global trade sanctions and navigating the pharmaceutical debate, and the WCT pulling 19th century copyright law into the digital internet age.
It is a continuously evolving ecosystem. Every single treaty is an attempt to balance the rights of the creator to profit against the needs of the global public to access innovation.
So what does this all mean for you? Well, the next time you take a generic prescription medication, or you buy a globally recognized brand online, or you stream a piece of digital content, realize that you are interacting with an invisible, deeply interconnected web of international law. The fence might be invisible, but you interact with it every single day.
And as we look to the future, the structural integrity of that fence is about to be tested again. Consider this. The 1996 WCT officially classified computer programs as literary works, specifically to protect the human beings who authored the code.
Okay.
But as we enter the era of artificial intelligence, a profound new question is emerging. How will an international framework, a framework fundamentally built in the 1800s to protect human authors, handle literary works that are autonomously generated by the very computer programs the WCT sought to protect? If the software writes the book, who owns the invisible fence?
Something to mull over until our next deep dive.